Welcome to another exciting episode here on the Professional Edge. My name's Sean Todd, tax attorney, CPA, and certified financial planner. We're talking about asset protection, and let's go along the lines of protecting the surviving spouse. So we talked about in session 1, if you had some rental property, about putting a liability protection fence around each one of those rental properties. That way one personal injury claim from a tenant is not going to taint and expose your personal assets to unlimited personal liability. So let's talk about that surviving spouse, part of your estate planning. A lot of individuals will draft wills, draft trusts, but they don't really do any asset protection planning. So let's put on that tax attorney hat and also think about it from a CPA perspective as well. So if you have this I love you will, unfortunately half of all our listeners here on the Professional Edge do not have any sort of estate plan in place. And that's where we offer emcthebundle.com. That is Echo Mary Charlie thebundle.com. It's a way for you to get your estate plan done, review your income taxes, and look at your portfolio on a very objective basis to come back to you with some written recommendations. Then that way we know that your estate plan's done, you've done some tax planning, and your investment portfolio is on track for that safe and secure retirement. Again, take advantage of that. That is at EMC Echo Mary Charlie thebundle.com. So back to surviving spouse. How do we protect assets for the surviving spouse? Well, if you have a last will and testament that gives everything to the surviving spouse, just outright real simple, you can download these off the internet. Well, that's amazing, right? It's free. Well, you're going to get what you pay for, and that's free. And so let's walk through the scenario. You pass away, everything goes to a surviving spouse. Well, the surviving spouse is real thrifty again, and because we have longevity, people are living longer and they're going to get married again. A lot of older individuals are getting married. Never thought about it, but we have kids of this first marriage. So one spouse passes, the other one gets remarried, and lo and behold, they have this bright idea. Hey, I know the website that my deceased spouse went to get our estate planning documents done. Well, lo and behold, they draft another I love you will. Well, when the second spouse passes away and that new spouse in this second marriage is going to receive the property because of this simple I love you will. Well, that second spouse has no legal obligation. Think about that for a second. They have no legal obligation to give anything to your children. Let that sink in for a second. They have no legal obligation to give anything to the children of that first marriage. So you have effectively, on the cheap, disinherited your kids. And think through this for a second. I see this happening. I've done 3,000 estate plans. I see kids come in after the second marriage and they show me this I love you will that is obviously downloaded from the internet. And they say, what does this mean? And I say, well, what it means is these assets go to that new spouse, and that new spouse gets all the property that your mom and dad have taken the lifetime to accumulate. And sorry, you are going to be, or have a great potential to be disinherited because they didn't protect the assets for the kids of that first marriage. So let's structure things a little bit differently. So it's called asset protection. It has nothing to do with estate planning. It has protecting the assets for the family, that bloodline. So what do? Well, we draft the estate planning documents correctly and forget about being free. It's a very costly mistake if you disinherit your kids, at least in my opinion. So let's draft the documents correctly so the surviving spouse has access to the assets. That's number one. Number two, they can be in control of the assets too. And then we're going to have a trust protector assigned to those assets. And yes, we are going to leave these assets in trust to the surviving spouse. Surviving spouse can be the trustee. They're going to be the beneficiary. There is flow-through taxation if we do it properly, so therefore we don't have excessive trust tax rates. And this is where the combination of being a tax attorney, a CPA, a certified financial planner, we bear this professionalism on the planning for our clients at estate management counselors. So to start this conversation and say, okay, this is making a lot of sense to me. I don't have anything in place. Do give our office a call at 877-654-9798. That number again, 877-654-9798. So inside the estate planning documents, and I don't know who's going to pass when, so we have mirror images. We are going to leave these assets in trust for the surviving spouse. Now, we've just protected these from the claims of creditors. That's number one. So if the surviving spouse is the defendant in a lawsuit, then these assets are not subject to the claims of that plaintiff. That's number one. But number two, along the lines of not disinheriting your kids, what we do is say, surviving spouse can access these funds. They're in charge of these funds. But when the surviving spouse passes away or gets remarried, they cannot leave these assets via a I love you will to the new spouse that they marry, husband to or wife to. So we guarantee that the assets left to the surviving spouse are going to go down to the kids of that first marriage. We're going to protect that bloodline. So we have to where the surviving spouse is going to be the trustee. Again, they're the beneficiary, but we have a trust protector, and that could be one of the kids. It could be an attorney that stands by and says, wait a minute, we're not going to distribute out $100,000 and put it in the joint checking account with H2 or W2, husband number two and wife number two. There's no reason for that. So therefore, that distribution is not going to take place, because then if it goes into that joint bank account, when the surviving spouse passes away, it's going to go to H2 or W2, wife number two or husband number two, because the operation of how that account is actually titled. So let's avoid that. But we want to protect those assets for the family that has been together earning these assets, and so we don't disinherit the kids. So again, it has to be in the estate planning documents, and we got to make sure when we do this type of planning, we actually coordinate the titles on things, because titles supersede what is in an estate plan. So if we have a bank account that's payable on death to someone, but in the last will and testament, we have it all going to the surviving spouse. Let's say I have a bank account and it's POD to my son, and my last will and testament says I give everything to my spouse. Well, whatever is in that bank account, and it could be the bill paying account for all that matters, and I keep $100,000 in there. And my spouse thinks that she's going to receive that $100,000 bill paying account. Well, that's what the will says, but when you interpret the full estate plan or the lack thereof, then that account that has a POD designation supersedes whatever is in the last will and testament or trust document itself. So that's why a coordinated approach, that payable on death account is going to go to my son. It's not going to go to the surviving spouse. That's by law. So we got to make sure there's a coordinated approach to your estate planning, and being a tax attorney, CPA, and certified financial planner, we bring that level of competence to our clients at estate management counselors. So if you want to have that level of confidence that your plan is coordinated, the asset titles are coordinated, and the beneficiary designations on your account are coordinated as well, do give our office a call at 877-654-9798. That number again, 877-654-9798. Or The better thing that we are offering our listeners here on the Professional Edge is called the bundle. We do your estate plan, we review your income taxes and do some tax planning, and we also review your investment portfolio and come back to you with some written recommendations that oftentimes stockbrokers or 1-800 firms are not licensed to give tax advice. Look at every statement. This is not tax advice. We are not licensed to provide tax advice. Seek tax counsel. It's all these disclaimers that they are not going to give you any tax advice. Well, I think it's more important to have tax planning advice integrated with your financial decisions. And that's what we do at Estate Management Counselors, being a tax attorney and a CPA. Why wouldn't you? Every financial decision you make has some sort of tax impact. Think of one that doesn't. There isn't. It doesn't exist. So again, to start that conversation, give our office a call at 877-654-9798. So going back to the essence of what this session is all about, we don't want to disinherit the kids. So therefore, we're going to structure your estate plan, make sure the titles are properly done as well on your accounts and your beneficiaries, and let the surviving spouse have access to the monies. And then we are going to guarantee that when the surviving spouse passes away, if they're remarried, that new spouse is not going to receive these assets. They're going to go down to the kids, however you wish, in equal shares for them to receive from the family, the blood protection. We're protecting that bloodstream, sort of like a racehorse, right? We can, make sure that that line is protected in our planning. So if that is of importance to you, again, guaranteeing that your surviving spouse is not going to disinherit the kids. And I know you're both looking at each other right now in the car and you're like, oh, is that going to happen? No, I'm not going to happen. That's not going to happen. Well, but if you're thrifty and you've done that I love you will from the internet, and the surviving spouse stays thrifty, which they normally do when they get that I love you will from the internet again, guess what? You just disinherited the kids. So let's not do that. Let's do the proper planning. Give our office a call at 877-654-9798. That number again, 877-654-9798, and get things in place that we guarantee we asset protect this inheritance that the surviving spouse is going to receive, that they actually guarantee that the kids are going to receive this balance when the surviving spouse passes away. I appreciate you listening to the Professional Edge. My name's Sean Todd, tax attorney, CPA, certified financial planner. More coming up here on the Professional Edge.
We've all thought about it. Everyone listening will need one. Not having one can cause untold heartache, family conflict escalating to the point of a lawsuit. One simple thing that avoids all that: an effective estate plan. As a practicing tax attorney, Sean Todd with Estate Management Counselors has completed over 1,000 estate plans during his 15 years of professional practice. He can help you implement an effective estate plan, coordinate your financial accounts, and make sure you have named the proper beneficiaries to maximize your tax savings. Call 877-654-9798 today and let tax attorney Sean Todd help you implement an effective estate plan. Call 877-654-9798 today. As a tax attorney, CPA for over 15 years, Sean Todd has implemented over 1,000 individual estate plans. He has recently authored an especially helpful guide, How to Unlock the Ultimate Estate Plan. This guide has helped many individuals to understand the benefits of an estate plan and how to avoid unintended disasters. Sean has made every attempt to write this in plain English. To receive this valuable guide, How to Unlock the Ultimate Estate Plan, call 1-877-654-9798 and request your complimentary copy today, or by emailing your request to info@emcadvisors.net.